I mention a matter for reconstruction. And your lordship was pleased to allow my lord therefore mentioning and send it to the department. Now, my lordship, kindly see what the department says. My lord, I am giving letter to all the concerned that the appeal was disposed of only an application for recording death was. Now, my lord, today as treated as a base, this your lordship, my lord, passed the order for reconstruction. My lord,
No, no. What was the order last occasion?
yes, last occasion the order was passed.
Now the question is this file is not traced out.
Not traced out.
Anyway, I'm passing an order directing the registrar Elano to look into this matter so that.
Your lordship, kindly keep it by the memo of appeal and the last
No. I regarding reconstruction. Prior to that, let me direct the registrar Elano to look into this. Is record an order?
Yes, I'm grateful.
Learned advocate for the claimant in appeal number FMA. What is the number?
FMA 3680 of 2015.
3680 of
2015.
2015 submits that the matter which is disposed cannot be implemented. The order cannot be implemented as because the file is not traced out. In the facts and circumstances, the registrar LNO is requested to take necessary steps in this matter and submit a report on or before.
No, my lord, day after tomorrow, my lord.
Okay. 7/1/2026, as the matter was disposed by the order of Lok Adalat. In the event the file is traced out, let it be sent to the Lok Adalat by the registrar LNO.
The ancient local kindly mentioned.
I mentioned.
On 13 December.
Whatever it is, Lok Adalat to be held in the month of December.
Particular mention.
No. In the month of December, there is only one Lok Adalat.
My lord,
I'm grateful.
second appeal ready for hearing, my lord.
Okay, January.
January, kindly fix the matter, my lord.
January it will appear to be mentioned. Thereafter, in the presence of both the parties, date will be fixed.
May I be permitted to mention, my lord, I am for the appellant application for stay.
Yes, January.
The appeal has been disposed of by your lordship, my lord, for small correction. File is lying in your lordship's court, my lord. Tomorrow to be mentioned.
No. What is to be corrected?
My lord, the name and my lord direction to the learned Registrar General for disbursing the amount. Only to this extent.
Anyway, I cannot assure you regarding tomorrow, but definitely in the month of January it will appear. Yes, give
My
it.
lord, your lordship, my lord, allowed.
Whatever it is. আচ্ছা ফাইলটা যদি থাকে কালকে এটা লিস্টে দিয়ে দেবেন
File is lying before your lordship. এসে গেছে, আমি লিখে দিয়েছি।
Number 2.
In this matter, Lordship, I am on behalf of the complainant, appellant, and I have already filed the affidavit of service.
So any application is pending to be disposed.
It has been disposed of. During the pendency of this appeal, Lordship, the advocate of the appellant and the advocate of the opposite party both has been expired. And
So take necessary steps and then mention.
I have already taken the steps.
Any application filed.
Application already been disposed of. The order has been annexed along with the affidavit of service, my lord. It has been passed on 11th September 2025. Paperwork has already been filed in the department.
So you are appearing for the opposite party, appellant Sukumar Sadhuka.
My lord.
Okay. Who expired?
Expired advocate Krishna Kamal Das was appearing on behalf of the opposite party, number 2.
That is the United India Insurance Company.
My lord.
So serve the insurance company and come in the next
copy
month.
has been, I have already served the notice.
Matter is ready for hearing.
My lord, the paperwork has been filed.
Yes, record an order.
So far my knowledge is concerned, my lord, the advocate Porimal Pahari has been engaged in this matter.
Okay, then you serve him a notice also, ascertain and serve him a notice also. Learned advocate for the appellant is present. The copy of the notice is already served upon the opposite party. Insurance Company. Let this matter appear under the heading to be mentioned on 7/1/2026. Learned advocate for the appellant is requested to serve one more notice upon the opposite party, United India Insurance Company.
My lord.
The affidavit of service file be kept with the record.
My lord, the paper book has already been filed. Kindly.
Paper books.
Paper
Anyway,
book has already been
let
filed.
us see. Come on the next.
My lord, my lord.
Yes.
Yes, my lord, this appeal has come, my lord, at my instance for correction of a, my lord, the calculation. Your lordship, kindly see the order passed by your lordship on 2nd December 2022. My lord, here the disease was dated about 51 years. As per the, my lord, the pronunciation or the Sarala Pharma,
No, you want any modification of this order?
not
Then
on the
Calculation. Yes. What is the calculation?
Your lordship, kindly see. Kindly see এই কপিটা দিন জজকে, আমি পেন্সিল দিয়ে করে দিয়েছি, এখানে করে দিয়েছি লাস্ট পেজে। Your lordship, kindly see the page number 6.
Page number 6. Yes.
My lord, your lordship, my lord, take my lord 3,000 per month. My lord, I have no objection. But as the victim was, my lord,
Multiplier is to be.
multiplier is to be 11 instead of 9.
Yes. So you let the other side come in his
My
presence.
lord, yes, I have given notice.
No,
my
give
lord.
one more notice. Otherwise, you
No,
do
my
one
lord,
thing.
I have given my 2 notice.
You see, I am varying an
My
order.
lord, he has no objection. He says.
Let
He-
him come. Yes, record an order.
My lord, he says, my lord, he has no objection. I have given notice, my lord.
Learned advocate for the claimant appellant is present.
I have given notice,
In
my lord.
fact, no. Did he say no objection?
My lord,
He has received the notice.
he received
Okay.
the notice.
The matter is put up for necessary rectification with regard to the calculation of the amount of compensation. As the respondent opposite party is not, respondent insurance company is not present, in the interest of justice, one more notice be served upon the opposite party insurance company. Let this matter appear on 6/1/2026.
6 tomorrow,
No.
today.
Tomorrow it's not. 6/1/2026. কোথায়? না, FM এটা ঠিক আছে। কোনটা? আইটেম নাম্বার? অ্যাডমিট নাম্বার 6 না কত? আইটেম নাম্বার 3। এটা FM না, এটা তো হয়ে গেল। 3 নম্বর তো হয়ে গেল। 4 রিভিউ পিটিশন। না, ঠিক আছে, দেখি রিভিউ পিটিশনে কার অর্ডারটা আছে। ঠিক আছে, দেখি। না, এটা দেখে নিই, মানে রিভিউর জন্য আলাদা পেজ আছে তো। Yes.
Well, I don't know, for your lordship, may kindly release this matter.
There is a bench to hear this review.
Your lordship, kindly release this matter.
Yes, record an order. Learned advocates for the
Want of determination, your lordship, kindly
learned advocate for the applicant
applicant.
is present. As this court does not have determination, let this matter be
Yes, sir.
released and placed before the bench having determination.
My lord, we are missing your lordship, my lord, for some days, my lord.
Yes, 2 weeks this bench will not sit.
New Year, we will meet in the new year.
Yes, definitely.
And we pray your lordship good health, my lord.
Yes, thank you. Same to you also.
Number 6.
Item 6, not this week আছে তো।
But this has come up at my instance. My lord has been pleased to fix this matter on 6 January 2026 at 3 p.m. my lord. But inadvertently, my lord, when matter was taken up, it was not brought to your lordship's notice that the interim order is expiring on 19th, my lord. I was
Which
busy.
case? Yes.
My lord, on the last occasion, lordship was pleased to take up this matter on 9th December and fix the matter for 6th January at 3 p.m. for hearing.
Yes, record an order. Learned advocate for the petitioner is present. This matter is due to appear on 6/1/2026. Stop.
At 3 p.m.
As the interim order which was granted earlier is going to expire
On 19th, my lord.
on 19/12/2025. The interim order stands extended till 15/1/2026 or till further orders, whichever is earlier.
Obliged.
In this matter, I am for appellant, my lord. I don't know. Item 9. My lord, I am for appellant. This is ready. I have filed. Talwano has been filed on last date. On yesterday, one advocate, Mr. Somalu Ganguly, was appeared. But today I did not see him.
So the appeal is ready for hearing.
Ready for hearing, my lord.
My lord, I am online today. My lord, is appeal is ready for hearing.
Oh,
So
so
paper books are already filed.
no, mother, kindly allow.
Yes.
We have received the copy, my lord. We have received.
For the parties are present, as this appeal is ready for hearing, let the same appear on
Any,
13/1/2026.
my lord.
The paper books file be kept with the record.
My lord. Much. Sure.
I am appearing for the claimant's appellants, my lord.
Appeal for the respondent insurance company.
I filed 2 applications. My lord, KN 1 is section 5, my lord. Delay of 12 days.
Yes. Yes, you are for the insurance.
Respondent 1.
Yes, record an order. Learned advocate for the appellant and learned advocate for respondent number 1 insurance company is present. The application CAN 1 of 2025, which is filed for condoning the delay in preferring this appeal, is taken up for consideration. Our learned advocates produce the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court finds that the appellant has shown sufficient grounds for condonation of the delay. The delay of 15 days in preferring this appeal is condoned. CAN 1 of 2025 stands disposed.
My lord, CAN 2
Yes.
for recording date of appellant number 2. During pendency of the appeal, my lord, the appellant number 2 died.
So
other,
the heirs,
other appellants are the legal heirs of the.
no, the other appellants, who are this 1, 2, 3, 4?
Yes. 1, 3, and 4.
1,
1, 3, and 4.
they are already on record.
Already on record.
Yes. The application CAN 2 of 2025, which is filed for recording the death of appellant number 2, Proshen Dhara, is taken up for consideration. The appellant number 2 died on 7/9/2013, leaving behind appellant number 1, 3, and 4 are as legal heirs who are already on record. Stop. As the legal heirs of the appellant are already on record, there is no question of any amendment. Thus, the name of the appellant number 2 be deleted from the cause title. The department to carry out the necessary amendments within 2 weeks. Liberty to mention. The paper books file be kept with the record.
না ওটা লিবারেল ডিপার্টমেন্ট কারেকশন করবে ওটা জানুয়ারি মাস বলে দেবো। থ্যাংক ইউ।
Item 11, my lord. We appear on behalf of respondent 4578, 17, 20, 21 to 26. No, 21, then 23 to 26. My lord, it has been recorded in the earlier order dated 28 March 2024. I have annexed.
No, whose application is this? Can
Yeah.
3?
He has taken out the two applications,
Can 3 and can 5?
can 3 and can 5. Yes.
Yes. What is this application
Yes.
for?
My lord, I tell you, lordship. Acha. I am for the appellant. my lord. I prefer this appeal.
Yes.
Now appeal has been admitted. But
Yes.
at that point of time, at the time of admission, my lord, actually there was no stay application of nothing of this sort. In the meantime, my lord, I made an application for injunction. Your lordship, can you just bear me? Then it will be easier
Yes.
to understand. I make an application for injunction. Now, while my lord, there are so many different respondents are there. I, my lord, serve the notice to the parties. Now it has returned some, my lord, in respect of some respondent, my lord, most of the large, my lord, the numbers, my learned friend is appearing on behalf of the respondent. Some of the respondents, my lord, it has come with the postal demand that insufficient address, some of them died, some left. These are the things. Thereafter, my lord, in pursuance of this, my lord, I filed the affidavit of service. The liberty was granted again to serve. I have served it. Now, some of the respondents which was returned with the postal demand, insufficient address left, but they have received it. Only, my lord, 3, 14 and 22. It was, my lord, it could not be served. They are not traced out. That is why I made an application for expunging their name. Earlier, my lord, I made an application for expunging this all
What
code.
related to this dispute?
No, my lord, actually they are not. They have not even, my lord, appeared before the learned
No, no,
court
but
bill also.
Are they related to this dispute?
My lord, I tell you, lordship,
But-
my lord, I find, my lord, subject to
You are
what
for?
I am for the respondents, which, my lords will be pleased to find. Our names have been recorded. We are, my lord, the respondents number 4578, 17, 20, 21, then 23 to 26, 30, 31, 33, 35, and 39 to 45. Now, my lord, kindly for a second, my lord, consider that this is a suit for declaration and for eviction of the licensees.
Yes.
Now, so far as the particular case is concerned, I was a defendant in the learned court below. Now, my lord, it appears, my lord, from the judgment delivered by the court of the first instance, that, my lord, the suit was decreed on contest against the defendants, and it was also declared that the defendants were the licenses under the plaintiffs, and their licenses had been revoked by the plaintiffs. Accordingly, the decree of eviction is awarded in favor of the plaintiff, but against the principal defendants with respect to their suit property, with a direction to the principal defendants to give up the cash and vacant position of the suit lands in favor of the plaintiff.
There was a decree was passed in favor of your learned friend's client.
Yes. Now, then, my lord, we prefer an appeal.
So that was set aside and the matter was remitted.
No, I say, my lord, only one thing, your lordship, my lord, kindly consider, had it been a case, kindly come to the order, my lord, or the judgment, my lord, which is delivered by the appellate court. Appellate court considered the appeal. Appellate court, my lord, was pleased to set aside the judgment and decree.
Yes.
Then this is the most important thing. The case is sent back on remand to the learned court below with a direction to mark the certified copy of the record manual as exhibit for proper appropriate parties, that is defendant, for the purpose of proper adjudication of the suit. The learned court below is further directed to give both parties to the instant suit a fresh opportunity to adduce evidence
and also to dispose of the case in this regard within a very short period, if possible, preferably within 6 months. It is directed that the learned court below must write the judgment afresh in the light of the available new materials.
That is
This
your
was the
merit.
judgment.
So, being agreed by the judgment, your learned friend
Preference.
has, this is first miscellaneous appeal.
Yes.
So, now in order to decide this appeal,
Yes.
the necessary parties are required to be served.
Yes,
Okay.
I have served.
That's
All of them
that's a-
received. All of them received.
State of West Bengal is represented.
Yes,
Yes.
yes. That was-
My learned friend is representing the state of West Bengal.
Now the question is, so how many respondents are there remaining unserved?
Only 3. 3, 14 and 22. My lord, they are not traceable. That is why, my lord,
With regard to the respondents who have died, you have taken steps.
my lord,
That,
So,
no,
those who have
that I have taken the instruction. I do not know. I can come up to my lords with the instruction as to
So
whether.
what is this application for Can 3?
my lord,
For relief.
can 3 is the injunction application.
There is
Your
no
kindly
scope
see.
for injunction.
No,
So far as
Are
the
Amar-
matter is concerned.
No, Can 3 is there.
My lord, your lordship kindly see. Just bear me, my lord, with regard to the Can 3.
Yes.
Can 3, my lord, I made an application. My lord, when the matter was my lord, admitted for admission, at that point of time, my lord, no step application was there. Due to inadvertence, it could not be filed. Now the appeal has been admitted in the year of 2020. Justice, my lord, Tandon or your lordship, division bench comprising Justice Tandon. Now, during the currency of this appeal, my lord, during the pendency of this appeal, now the trial court, my lord, passed an order in my favor. Order of eviction was there. My lord, there was an injunction is also there against them. Now they preferred appeal. Appellate court, my lord, set aside them. Now during the pendency of this appeal, my lord, they have, my lord, changed the nature and character of the suit. They have started the construction over there. Their case is that they are the permission.
Is your position disturbed? Well,
Yes, that is why I approached before the, my lord, the police authority. Police authority has not taken steps. That is why I made an
that means
application
you obtained an eviction decree against
them.
Okay.
Now the appeal, they preferred appeal.
Yes.
The appellate court, my lord, set aside the, my lord, the judgment and degree
Yes.
passed. I preferred the, my lord, the appeal before this honorable court. It was, by mistake, it was preferred as a SAT. Actually, it will be FMAT.
So now,
Because it is a
now
demand.
present application is Can 3.
Can 3. And during the, my lord, when the Can 3 was served, this
And
is
this
the
Can
outcome.
5 is for what?
For the expunging the name of the 3, 14 and 22.
3, 14.
And 22. And in the meantime,
No, are they occupying the suit property? 3, 14 and 25?
no, actually they have not appeared also before the learned court bill. They have not filed any.
3, Salahuddin, 14.
Okay. My lord, they are not traceable. We have tried our level best. We made application twice.
14 and
3, 14 and 22. I have stated, my lord, in
But
detail.
in the application, it has been stated 3, 14 and 20.
Huh?
Kindly see page 16 of the application for expunsion.
Oh, it is mistake, my lord. It will
3,
be 22.
14 and 20 has been indicated in so far as the prayer is concerned.
22.
Actually, it will be 22. I stand corrected. It will be 22. Because from my lord,
And in the
3,
bodies
14
of the
and 22,
petition also, it finds that
what was
22 has been.
no, in the particular suit before the trial court, you sought their eviction also, 3, 14 and 22.
That
but
is
if they are not traceable, I have tried my level best. My lord, twice I made an application. Sometimes some of the respondents, my lord, it has returned postal remark. Again, as per order of the honorable court, I served them. Some of them received, some of them refused. Now, in respect of 3, my lord, we are under.
One thing you can take steps for substituted service. That opportunity can be given.
Actually, your lordship kindly see, just a land, my lord, situated Uttar Dinajpur border area of the Bihar and Bengal.
Yes.
My lord, some of them, my lord, residing at Bihar, my lord, due to the partition, and some of them, my lord, the Bengal. Now, my lord, as per the direction of the honorable court, we have tried our level best for serving copy, though in respect of some of them returned answered, but again I have served, they have received it. Some of them refused.
Now the question is, if
Now,
somebody is not
Well,
traced
if
out,
they are not traceable, how it can be done?
substituted service that is there.
Well, they are not traceable.
You see, your obligation will be discharged the moment you file take steps for substituted service.
But if they are not, I have stated, my lord, your lordship kindly see in paragraph, I have stated in detail in the in paragraph. If, my lord, it is not traceable, your lordship kindly see. My lord, there is an order of, there is also an order, your lordship kindly see. I have annexed the, my lord, the order. Your lordship kindly come page 18. Earlier, your lordship kindly see. Page 18, your lordship kindly come.
Yes.
At that point of time, my lord, there a can 4 was there. My lord, my learned friend, my lord, appeared on behalf of the, that is recorded. Now, respond number 3, 9, 10, 11, 13 have not yet been received, such and such. And some of them
There was a
thereafter, my lord, his lordship directed, my lord, to serve again. I have served. Now, my lord, after serving, my lord, I filed it. Thereafter, my lord, your lordship kindly come next page, page 20. Can 4. Can 4 was, my lord, made, my lord, for serving notice to all the parties for expunging the name of more than, my lord, 3, 4 and 22. Now, my lord, as they have received, some of them refused. So the the honorable court held that yes.
Okay, 3, 14 and 20.
Now, liberty was granted me to, my lord, the respondent 3, 14 and 20. I have, that is why I made them application. But they are not traceable. They are not traceable. I have tried my level best twice or thrice.
Now you see what happens is this: when you see, if there is a reasonable apprehension that some persons are avoiding notice or they have left,
yes,
they may have left that area, whatever
yes,
it is. Courts can direct substituted service. That can be done.
Substituted service, my lord, if the address is the same.
Yes, yes. You see, substituted service means publication.
Yes.
Paper publication. That can be done.
So that they come to know that this is a proceeding.
Otherwise, a special officer can be sent from this court to ascertain whether they are living there or not, or where they have gone.
May direct the learned court below. The persons who are writing up the decree, your lordship knows below that they have.
No, it will take time, my lord. It will take time. Your lordship kindly see, as per order of this earlier bench, my lord, LCR has come. Notice has been, my lord, issued to me for preparation of the paper book. Due to this reason, the paper book could not be prepared. That is the only difficulty. That is the only difficulty.
So, pursuant to this order dated 12/12/2024, this.
Yes, I have filed this application.
So they have stated that they are not traceable.
Not traceable. They are not traceable.
And in the trial court, they have not appeared.
They have not appeared. They have.
Trial court and the appellate court.
Both the courts. My lord, only my learned friend clients, my lord, have filed the written objection.
Yes, record an order.
That is the order.
Learned advocate representing the appellant, learned advocate representing respondent number 1, State of West Bengal, and respondent number 1 and 2. Yes. And BLLRO, West Dinajpur, BLLRO, Balurghat. And learned advocate respondent number. How many respondents were responding?
Milord, that has been indicated in the order of 12/12/2024.
আচ্ছা 12/12/2024 অর্ডারটা দিন তো।
No, it is my lord. I have annexed the order in the application. Your lordship kindly come. Page 18. I have annexed all the orders.
Respondent number 3, 9, 10, 11, 13 to 16 and 22 are also present. This application, CAN 5 of 2025, is filed for dispensing service of notice.
Not 3, 4.
Okay. For dispensing
4, 5,
service of notice upon respondent number. No. So this is this CAN 5.
Yes, can 5, yes.
No. What is your prayer? You see, you have prayed for.
Expanding the name.
No. Yes. Delete the names.
Yes, delete. At my risk.
No. Delete them. You see, the names remain. Service may be dispensed with. Why it will be deleted? It's not that these persons are dead.
All right, your lordship.
Okay. Delete the names of respondent number.
The application can file will verify is filed for dispensing service of notice upon the respondent.
No, to delete the names, sorry. Delete the names of respondent number 314.
This application can file is filed.
Yes, file with a prayer to delete the names of respondent number 3, 14 and 20 from the memo of appeal.
22.
No, 3, 14 and 20. Prayer is 3, 14 and 20.
22.
Or it should be 22.
No, actually it will be
20 I am appearing.
okay, 22. It will be 22.
3, 14 and 22.
22.
Learned advocates for the petitioner appellant submits that earlier notice was sent, but it has returned that the said respondents are not traceable. Stop. It is further submitted that the said respondents did not appear before the learned trial court and the learned appellate court. Stop. In the facts and circumstances, this court is of the view that this is not a case where the names can be deleted. Stop. Thus, the names will remain in the cause title as because they were parties to the suit. Stop. However, as these respondents are not traceable and they have not appeared before the trial court and appellate court, the service of notice upon respondent number 3, 14 and 22 is dispensed with at this stage. Learned advocate is granted leave to make necessary correction in the prayer portion of the petition.
Yes.
So let this matter appear after vacation.
My lord, with regard to the can 3, my lord.
Can 3?
Yes.
You have prayed for what?
My lord, I am praying not to, my lord, change the nature and character of the suit property.
Which has been done.
Have you filed any opposition to this?
No, I have not filed any.
Yes.
Petition.
Can 3 of 2023 is taken up for consideration. In the said application, the appellant has prayed for an interim order restraining the respondents, opposite parties, from changing the nature and character of the suit property and prohibiting them from making any construction over the land as involved in the present dispute.
Kindly record my submission because I have taken the instructions.
Disposal of the instant appeal. Learned advocate appearing for respondent number 3.
No, 3, not 3, 4, 5, 7, 8.
Okay. 4, 5,
7, 8.
4, 5, 7, 8.
17.
Okay, just a minute. No, this is 3, 9, 10, 11. Yes. You are learned advocate representing respondent number 4, 5,
7, 8.
7, 8.
17.
17.
20, 21.
20, 21.
23 to 26.
23 to 26.
Then Miller 30, 31.
30, 31.
33, 35.
33, 35.
And 39 to 45.
And 39 to 45 submits that at present the respondents have not taken any steps to construct anything on the suit property, nor they have taken any steps to make any addition and alteration of the nature and character of the suit property.
I have taken the specific instruction. After Miller, I find that the matter has been fixed by the court.
In the facts and circumstances, as it is submitted by the learned advocate representing the said respondents, further order of injunction is not required at this stage. Thus, affidavit in opposition be filed by the respondents within 1 week after vacation.
Kindly make it 2 weeks.
Within 2 weeks after vacation. Reply, if any, within 1 week thereafter. Let this matter appear on 27/1/2000.
27/1.
Yes.
Or may I pray one thing, my lord?
Yes.
When they are saying that we are not making, let status quo to be maintained, my lord.
Why?
It will not harm anybody.
No, why?
It will not harm anybody.
However, with regard to the other respondents, it is directed that the status quo be maintained.
Maintained, yes. Let status quo to be maintained.
This is nothing but an indirect way of getting an order from the court and informing the client, because this status quo order, this will again create confusion.
But it
Why?
has to be maintained.
Yes,
Yes,
I say, Milord, I as an officer of the court,
Yes.
Milord,
But
I have
the other respondents are concerned. They may take steps.
yes.
So for the other respondents, they are directed.
That's
maintain
right.
status.
That's right. They can tell you, of course,
Yes.
they should. Rather, they should, Milord, comply with the order passed by the learned courts below.
Yes.
I'm grateful to my lord.
Yes. Can 3 stands disposed.
Disposal, yes.
That is for this dispensation.
Yeah, disposal.
And can 5 is pending.
No. Can 3 is pending. Can 5 is
Can 5 to disposed হয়ে গেল।
Can 5 to dispose.
যেটা dispensing with.
Unless my lord, this application is my lord disposed of, I have been served with notice for preparation of paper. That is the whole.
Okay, come on the
Yes,
next.
here has come.
On the next day, I shall pass direction to file the paper.
Yes. Able to দেবেন তার correction টা। একটু এই অ্যাপ্লিকেশনটা দেন।
Number 12 and 13.
12 and 13 is the appeal of Mr. Singh of the insurance company, but a matter has come at my instance. I have filed an application for lawsuit expunging the name of the claimant respondent number 3 on death. Lawsuit kindly, I have that is in Can 3 died intestate, leaving behind the other heirs. All heirs are already on record, so the name may be expunged. And Lordship, second point is that the appeal before the insurance company, Lordship, the matter will be heard by your Lordship on merit basis 2010. So Lordship, 15 years already been.
This is an appeal of
into that.
2024.
2024, but the
Claim case
instituted or 2010, Lordship.
Actually, you see, so far this motor accident claim cases or appeal are concerned, to some extent, these are being disposed expeditiously compared to other cases.
Lordship,
Other cases are pending for several years. But so far these claim cases are concerned, both in the trial court and this high court, it is being proceeded with.
So Lordship,
to some extent.
With expectations, Lordship will.
So let us try our level best so that in this field it can be proceeded with expeditiously.
2026, Lordship will.
Yes, record an order. Learned advocates for the parties are present. The application Can 3 of 2025 is taken up for consideration. The appellant petitioner has filed this application for expunging the name of the appellant number 3.
No, Lordship, respondent.
Okay, respondent number 3, Basdei Devi, on account of a death. Stop. As the heirs of respondent number 3 are already on record, there is no question of any substitution. The name of respondent number 3 be deleted from the cause title. The department shall take necessary steps to carry out the amendment within 2 weeks. Liberty to mention.
Lordship, kindly fix the immediate on 2026.
You mention, it will appear and I shall fix the date. After these amendments are carried out.
Yes.
Grateful to your Lordship.
Consider disposed.
Before we now.
That's a giant for the applicant, Lordship, claimant respondent. Lordship, This case already disposed of, but Lordship, minor correction is needed. Correction in this regard, Lordship, respondent claimant widow and her son also residing in their canton. Lordship, respondent claimant widow and her child also residing in her Lordship's paternal house, and that address
You
has
want
been-
to cause necessary rectification in the address of the
Yes, yes.
address of
Added,
the
Lordship, added. He also residing, also, Lordship, I have stated in paragraph 3.
no,
Lordship,
you want to cause necessary change in the address of respondent number 2.
1 and 2.
1 and 2.
1 and 2. Ramakrishna Polli, Matpada, which has been, Lordship's endorsed in her Lordship's voter card and also Aadhaar card. That's why problem arises, Lordships. They are residing in in-laws house and also her maternal paternal house, and that should be Lordship recorded.
Yes, record an order. Learned advocates for the parties are present. This application is filed for amendment of the
First title.
first title with regard to the names of the respondents number 1 and 2 about their residential address. Stop. It is the contention of the applicant's respondents that the applicant's respondents have shifted to a different place as mentioned in paragraph 3 of this application. And
that should be added, Lordship.
And
Ramakrishna
the
Polli.
address of the respondents be changed.
Lordship, add, not change, Lordship.
Oh, the
Add. And also
the address as mentioned in paragraph number 3 be added to the present address of the respondents number 1 and 2. As this application is formal in nature, the same is allowed. Let necessary amendment be carried out within 2 weeks. Liberty to mention.
Not
within
already disposed of.
Yes, yes, can is
Lordship,
disposed with
appeal also disposed.
Lordship,
Okay.
within 2 weeks, not within weeks, but because Lordship already checked issues, and that's why Lordship today your Lordship send down this file, then Lordship they will withdraw the check. That has been Lordship's limited period. Only 1 month is during in withdrawal.
Because Malad, after disposal, Malad, the Registrar General already issued check in their name in favor of respondent number 1 and 2, but due to the change of address, they are not disbursing the check. That is their problem.
Okay, let this amendment be carried out within 1 week. 1 week expeditious.
Lordship, I'm grateful, Lordship. Lordship, kindly order.
The files be sent to the department for necessary steps.
Lordship, I'm grateful, Lordship.
Huh? Can do is disposed.
Yes.
নামটা দিন item 15.
Lordship, in item number 15, I'm appearing for the applicant insurance company, my lord. This is my application. My lord, I've made the statutory deposit of 25,000 rupees, my lord. I'm submitting a copy of the same before your lordship, my lord.
Yes.
I'm praying for the stay to be made on the lower court proceedings, my lord.
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 20th August 2025, passed by Learned Additional District Judge, Fast Track Court, Rampurhat, Birbhum, in MSC case number 38 of 2014 for a period of 5 weeks. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the Learned Trial Court, excluding the statutory amount within this period of 5 weeks. Stop. In the event the awarded amount is deposited, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
Lordship. Deeply obliged, Lordship.
My lord, I on behalf of the appellants, has the affidavit of service. Taken on record. But there is a delay of 53 days.
So which application? Can one?
Can one. Delay of 53 days
Can two is for what?
is the appropriate order.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents. You have served both the respondents?
My lord, not both the respondents, to the insurance company, because the lower court.
None appears for the respondent number 2 in spite of service of notice. Stop. The application for condonation of delay is taken up for consideration. Heard learned advocates. Peruse the petition filed. Upon perusing the petition, it appears that the appellant has shown sufficient cause for the delay. Hence, the delay of 53 days in filing this instant appeal is condoned. The application Can 1 of 2025 is disposed. The appellant shall take further steps to cause service of notice upon the respondents once again through the department. Liberty to mention.
Lordship, item 17, I'm appealing for the appellant insurance company, Lordship. I'm willing to secure the entire amount, Lordship. I'm depositing the 25,000 amount, and I'm producing a copy of the same, my lord, for the Lordship's court. And I'm praying for the stay on the lower court proceedings, my lord.
Yes, record an order. Learned advocate for the appellant insurance company is present. The appellant insurance company has deposited the entire awarded sum. Oh, you have deposited the statutory amount only.
Lordship.
The appellant insurance company has deposited the statutory amount of rupees 25,000. Stop. Thus, there shall be an ad interim order of stay of the judgment and award dated 16th September 2025 passed by the learned additional district judge, first track second court Alipur, South 24 Parganas, in MSC case number 1337 of 2022 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within this period of 5 weeks. Stop. In the event the deposit is made within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Yes, liberty to mention.
I'm grateful, Lordship.
I'm appealing for the claimants, respondents in this matter.
Sir, I'm for the appellant, my lord. I file an additional.
Item
18. I filed one cross objection in this matter. This is my railway claims tribunal.
Yes. So paper books are ready.
No, my lord. I file an
application is pending.
I file an application for addition of party. Daughter of the claimant. Claim number 3 has not been made party in the appeal. That's why I file an application for addition of party.
Okay, you are the original claimant.
Yes.
Who is for the Union of India?
I am for the Union of India.
Oh, Union of India.
I file this appeal.
For to add this daughter as a party.
Yes, ma'am.
Yes, record an order. Learned advocate for the parties are present. The application for addition of party being Can 3 of 2025 is taken up for consideration. It is the contention of the
daughter no,
applicant that the daughter of the
wife,
victim,
my lord, daughter no, so wife.
No, deceased mother.
of wife of the deceased victim.
No, mother of the
Mother of the applicant
is the mother of the victim.
Mother of the victim.
It is the contention of the applicant that the mother of the deceased victim who ought to be added as a party is not done. Stop. In the facts and circumstances, this application is allowed. Let the applicant. What is the name of this applicant?
Tulekha De.
Tulekha De be added as a party respondent in this case. The department to take necessary steps for amendment within 2 weeks. Liberty to mention.
My lord,
There is a stay application also is also pending.
Yes.
Section 5 have already disposed of. So stay application may be disposed of on account of deposit of considerable amount.
Question is, the party be added,
Yes,
let
yes,
necessary
thereafter-
amendment be carried out.
Yes, sir. Thereafter,
in the next month you mention, after they are carried out.
yes, yes, I am grateful.
Yes.
The department took necessary steps for amendment 2 weeks.
Well,
Within 2 weeks. Liberty to mention.
my lord, one thing, my lord, your lordship kindly fix the date. Otherwise, my lord, it will not be correct.
No. I am in all matters I am directing. Let the amendment be carried out and liberty to mention. After it is carried out, do mention.
My lord. না না হলো না এখনো স্টেটা হয়নি আমার But I am appealing in this matter on behalf of the respondents claimants.
I am appearing on behalf of the appellant insurance company in 20. I have deposited the entire awarded sum before my lord's court. This is the photocopy of the challan, and 21 is my learned friend separate appeal, my lord.
File one separate appeal.
What is
Pending
this Can 1?
Yes. Can 1, my lord, in my case, Can 1 is section 5. Delay may be condoned, my lord.
Okay, let me see.
পরেরটা 21
And in my this item 20, Can 2 is the stay application. Let that be disposed of.
Lovely.
তাহলে কোম্পানি থেকে ফাইলটা আমি লোকালয়তে পরে দেখছি খুঁজে পাচ্ছি না
বলছিল
35 কপিগুলো আছে 35 কপিগুলো আছে
Can 1 না 2?
ওনার
আমারটাই Can 1
Can 1 21 Can 1
সেকশন 5 আছে জিজ্ঞাসা করো তো ওটা দিয়ে দেবো কিনা
একটা কল করতে
No, what is this Can 2?
His is Can 1 in 21.
I am taking this Can 2.
Can 2 is my stay application, my lord.
Oh, no, just a minute.
In item 20, Can 2.
1186.
Yes, that is Can 2, my stay application. I have deposited the entire awarded sum before my lord's court. Let my stay be absolute.
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the entire awarded sum along with interest in terms of the judgment and award dated 24th day of April 2024, passed by the learned additional district judge, Third Court, Krishnanagar, Nodia, in MSC case number 166 of 2017. The judgment and order of the learned trial court shall remain stayed till disposal of this appeal. As of the respondent number 1 and 2 are already represented. Service of notice upon respondent number 1 and 2 is dispensed with. However, steps to be taken to cause service of notice upon respondent number 3, 4, and 5
My lord.
through the department.
Well, it will take some time, my lord. And direct the appellant to serve notice.
3 and 4, my lord. This 5, I shall see to it that someone appears, my lord. It's New India.
Let me order, okay?
My lord.
Thereafter, you take steps, whatever you want.
My lord.
3, 4, and 5 through the department.
My lord.
The trial court's records be called for at the special messenger cost.
Yes.
To be paid by the respondent. Yes. Next, 1. Next is
723.
723.
এটা হয়ে গেল, এই অ্যাপিলেট ক্যানটা ডিসপোজড হয়ে গেল। নেক্সট অ্যাপিলটা দিন 21 ইয়েটা।
আচ্ছা আমি বলে দেব।
21 এর ক্যান আছে তো, ক্যান 1।
I am giving my the deconstructed copy, my lord. Kindly take this. The delay copy in আছে।
আচ্ছা, next. That is item number 21. Learned advocates for the parties are present. The application for condonation of delay being CAN 1 of 2025 is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that as sufficient ground is shown to condone the delay of 134 days in preferring this appeal should be condoned. Thus, the delay is condoned and CAN 1 of 2025 is disposed. The appeal is admitted. As the respondent number, you are representing which respondent? 1?
In item 21?
Yes.
Yes. Oriental Insurance.
Respondent number 1 has already appeared. Service of notice upon the respondent number 1 is dispensed with. However, service be caused upon respondent number 2, 3, and 4 through the department. The trial court's records be called for at the special messenger cost to be paid by the appellant. Liberty to mention.
My lord, in this matter, kindly delete this order, my lord. Since my lord, the pass this order, my lord, in the other matter.
2021, it's yes.
The trial court's record need not be called.
No, because
the trial court's record ওটা কেটে দিন।
that order is already there.
Otherwise, I have to put the cost twice.
Grateful.
Okay, liberty to mention.
Liberty, grateful, my lord.
My application, my lord, the substitution application upon the date of the sole appellant, my lord. But my lord, there are some latches, my lord. The delay ground has not explained, my lord. So section 5 application.
Question is, you see, if it is filed after the limitation, then you have to serve the opposite party.
Sir, my lord. Yes, sir.
Anybody has appeared?
Sir, liberty may be given to section 5 application may be filed, my lord.
Just a minute. দেখি রেকর্ডটা একটু।
Last order.
When did this this appellant die?
In the year of 2018, my lord. 7th
2000?
December 2018. It is at paragraph 2, my lord. Application number 2. Can application number 2, my lord.
Okay, record and order. Land.
এটা can 2 না can 1 দুটো can কি বেঁচে আছে ওখানে
এটা
হ্যাঁ
এটা এখন CAN 2 টা নেওয়া হচ্ছে।
আচ্ছা
CAN 2 is for substitution. Learned advocate for the appellant is present. It is submitted by the, you are not representing the appellant but the applicants.
Lordship, appellant applicants.
Appellant is dead. Now
Died.
this is the applicant. Learned advocate for the applicant is present. It is submitted by the learned advocate for the applicants that liberty be granted to file application for condonation of delay in this particular case. Thus, the liberty is granted. The application for condonation of delay be filed, and the application and the said application along with the application for substitution be served upon the respondents. Within 2 weeks, an affidavit of service be filed. Let this matter. No, you liberty to mention after you file the section 5.
The matter after vacation, my lord, then.
Liberty to mention after vacation. No, disposed holo na, pending থাকছে তো. Liberty granted.
My lord, I am appealing for the appellant, my lord. There was a deficit of court fees, my lord. I already paid the court fees, my lord.
My lord,
Yes,
last order records of 27th of November, I think.
I've already paid the court fees.
So there was a deficit in court fees. The last order record that they will have to pay the court fees. Last order.
একটু রিপোর্টটা একটু দেখে নিন।
হ্যাঁ, রিপোর্টটা দেখতে সেটাই লাগবে। রিপোর্ট আসেনি? রিপোর্ট 100% রিপোর্ট আসে।
যদি না আসে তাহলে ইনস্ট্রাকশন ডিপার্টমেন্টকে ডাইরেকশন দেব।
So deficit court fees is paid.
The fees court fees is paid. Now, my lord, what is required is the paper book, is the order admitting the second appeal records that the
There was a certified copy of the decree of the trial court has not yet been filed.
Is the difficulty is the paper book has not yet been done by the appellant.
No,
So
this
those
is the appeal of
formalities.
which year? Appeal.
This is of by an order of 21st of September 22, the second appeal was admitted. And it was recorded in that order that for the time being, the lower court records transmission is dispensed with. So, and the procedure, there is also injunction against me from proceeding with execution. And they will deposit current market rate, which they are doing. They are paying the current market. Now the appeal has to be heard. No matter I'm on instruction.
There is another report that certified copy of the decree of the trial court has not yet been filed. So you file the same.
Let me file that, my lord.
Okay, and another is certified copy of the decree on appeal is bereft of the date of judgment of that court. The same may be transmitted to the learned appellate court for necessary correction.
But only one thing. So far the paper books are concerned, I believe that the appellant, whether we'll do or not, because
You will file the paper book.
It's ready. It's ready, my lord. Will grant me leave because 2 paper books. Why I'm
These
saying
things is to be done. This certified.
that I will cure. That I will cure because I'm the eviction suit. So I have a.
And the other thing is this: that is the date of the judgment of
That
the.
we'll see that this has been these are complied with the whatever is there. But what happens in a second appeal? The paper book only consists of the decree of the first court, the first appellate court, and the certified copy of the memorandum.
Trial court and the appellate court.
Only 4 documents.
That is trial court, appellate court, memo of appeal,
and the order admitting the appeal. The only 4 documents in a paper book of a second appeal under the rules. That is ready. I have also prepared a supplementary paper book which consists all the pleadings, the plain, written statement, whatever are the pleadings for reference. Because the LCR is no more the lower court record, is the TCR today. The TCR is dispensed with. So I have told, we have obtained certified copies of all.
As because certified copies are ready, the certified copies may be filed.
Yes.
And the defects may be cured.
Yes. Lordship will give direction on us, we will cure this. And liberty be given to, we will furnish them the paper book.
Because the
also
certified copy of the decree, where the date of the judgment is not mentioned, that has to be
corrected, rectified.
Yes, record and order.
And there's a requisite copies must be, I think 5-6 copies has to be given in the department. We will give that.
Learned advocates for the parties are present. It appears in the report dated 3/12/2025 that the order dated 27/11/2025 for paying the deficit court fees is complied. Stop. However, it is pointed out by the AR section that the certified copy of the decree of the trial court has not been filed, and the certified copy of the decree on appeal is bereft of the date of the judgment of that court. Stop. Thus, steps be taken to cure the defects. The matter
Also, liberty be given to the because steps be taken in the sense the appellant will take steps.
Steps be
Taken by either of the parties.
By either of the parties.
Either of the parties.
Step be taken to cure the defect.
By either of the parties.
Yes. Defect cure koro tarpor hobe.
Upon curing the defects, parties are granted, learned advocates for the parties are granted liberty to mention.
Because the paper book will come thereafter, my lords.
Yes, you mentioned after the thing is
Yeah,
ready. Instead of directing the matter to appear, you mention whenever.
I'll mention, but paper book has to be filed.
Acha.
Paper book has to be filed. Thereafter, I'll mention in the next year. I'll mention in the next year, not in this year.
No, you're filing the paper books today or on the next.
No, department. You have to file in department.
Okay. The paper books be filed on
the requisite number of paper books.
The requisite number of paper books be filed
by the respondent.
By the respondents on or before 9/1/2026.
In that case, can you direct them to serve me a copy?
I will do that.
Yeah, 100%. Deeply obliged, madam. We'll mention thereafter.
Yes.
Obliged, deeply.
My lord, in item number 24, Mr. Sohini Chakraborty is appearing on behalf of the respondent number 225, my lord.
Appellant.
My lord, she's engaged in court number 40. I'm praying for not today, my lord.
So not today.
But will kindly takes it up on Monday, my lord.
Oh, they need after vacation. Is there any urgency in this matter?
23 district
One has died, my lord. For recording death, my lord, only. For one application is there for recording death and another for appropriate order, my lord. Filed by day, my.
So it is your application.
Yes, sir.
So let it come after vacation. I'm making it not this week.
Not this week, my lord. I'm grateful.
And for the applicant. File application, my lord.
Yes.
The delay of 66 days, my lord. Earlier occasion, my lord, it was filed and it was appeared before Honorable Justice Bihas Ranjan Day, my lord.
Let me see.
At that time, my lord,
Service is complete.
Lordship. Can.
So you have caused service of notice upon both the respondents. Yes. Yes, record an order. Learned advocates for the appellant is present. None appears for the respondents in spite of service of notice. The application for condonation of delay under Section 5 of the Limitation Act is taken up for consideration. Heard learned advocates peruse the petition filed. Upon hearing the learned advocate and perusing the petition, it appears that the appellant petitioner has shown sufficient cause for condoning the delay. Stop. Thus, delay of 66 days in preferring this appeal is condoned. This application Can 2 of 2025 is disposed.
Milord, in item number 26, Milord, I'm for the respondent numbers 1, 2, 3. I'm being led by Mr. Kaushik Dey in this matter. There's medical emergency in his family, so that's
So not this week?
Not today, Milord. Tomorrow we can have the hearing, Milord.
Because you see, tomorrow I'll be keeping few matters, and thereafter 2 weeks this bench will not sit.
It would be only very short matter.
Is there any extension of interim order?
Still today, Milord. It is still today.
No, it's better I take it up after vacation. Let it be extended till vacation. Okay.
Lord, it will be a very short matter. We will only argue on the
Whatever
point
it is, is there any dispute with regard to occupation charge?
Yeah.
So it has to be heard out, even if necessary on affidavits. Whatever it is.
But I would be submitting, my lord, let the main appeal be taken up, my lord.
Yes, I know your difficulty.
My
Your
client is
difficulty,
not
your,
in a position
your
to
difficulty
pay.
is only with regard to payment of occupation charge. You don't have any other difficulty.
No.
So this is the only difficulty. So I know your difficulty.
Mother,
Your friend has
is
some other difficulty.
Yes,
Your learned
yes.
friend.
That is all right, my lord.
Anyway, I'm extending the interim order. I'm keeping it after vacation. Both of you, please come ready.
But kindly fixes along with the hearing of the appeal also, my lord.
The paper books are ready.
Everything
My
ready.
lord, the can has to be disposed of first,
Okay.
my lord. The can has
Record
to
an
be-
order.
But we would hardly take
And-
10 minutes,
So
my
how
lord.
long you are occupying the suit premises without paying occupation charge?
No. During the pendency of the appeal,
No,
we
first
were,
appeal.
yes, we were paying.
Okay.
From the time of
2000
this filing of the second appeal, it has
Yes.
not been paid.
No,
Nothing has been fixed also. Nothing has been
2,200
paid.
How much you was paying?
2,200 per month.
2,200 at that point of time.
At what time?
But 2023?
2018.
No.
2000?
2023, last we paid.
Are you satisfied with that?
No, my lord. No, my lord. We have filed our
Okay.
opposition.
Come in the
also.
month of January. Learned advocates for the parties are present. Learned advocate for the respondents prays for time on the ground of some exigency. Such prayer is allowed. By consent of the parties, the matter is fixed on 9/1/2000. Yes. 9th on Friday. 9/1/2026. The interim order granted earlier stands extended till 16/1/2026 or till further orders, whichever is earlier.
Grateful, my lord.
Grateful.
But it could have been till the end of the month.
Okay, 16/1
That would be-
2020. Acha, let it be till 31/1/2026.
Lordship. Otherwise,
31/1/2026.
great.
My lord, item number 27. May I be, my lord, permitted to appear online, my lord? May I be permitted to appear online, my lord? 27, my lord, I am appearing for, my lord, the appellant, my lord. An appeal was admitted by the Honorable Division Bench by the order dated, my lord, 28th of November 2024. Thereafter, the interim order for stay of the proceeding in the court below was extended from time to time, and it ultimately expired with the expiry of month of August. But we have came out with an application. Mr. Haldar is appearing for the, my lord, he's my other adversary, my lord. Let the interim order be extended and the appeal may be heard. My lord, the point of law involved.
Responded, my lord.
You're for the appellant.
I am for the appellant, my lord.
So,
A suit for eviction, my lord, of a trespasser.
yes.
It was filed before the learned civil court. My lord, the defendant took out an application under Order 7 Rule 11D, praying for that the suit is not maintainable before the civil court. Learned trial court, my lord, allowed the said application, challenging that, my lord, the plaintiff.
Now, which application is to be, you see, appeal is admitted.
Appeal is admitted.
Now
My
the-
lord, can 3 is the, my lord, application for reimposition of interim order.
Can what?
Can 1.
Is for stay.
27.
Can 1 is for stay, my lord.
Can one for?
For stay. Initially, can 1 is filed for stay.
Can 3,
Can
my lord,
be
they
for
prayed for-
reimposition of the stay.
Yes.
My lord,
Reimposition
I tell your lordship, can 1 is for stay. Initially, an interim order of stay was passed.
Correct.
That was by expiry of time. That expired with
They
my
pay
lord.
occupation charges.
They are not paying
Oh,
anything.
because they are the trespassers.
They are
My lord, there was no application to that effect also. There was no application to that effect
of
also.
the property in question, but
No,
not.
in the appellate court, first appellate court, also they did not pay any occupation charges.
No, difficulty is that, my lord, initially, my lord, suit was held to be not maintainable before the learned civil court,
Yes.
challenging that my client preferred title appeal. That was allowed, holding that suit is maintainable before the learned trial judge, civil judge, and a matter was remanded back to the learned court below, challenging that they have come up before this honorable court.
And my lord, appeal was admitted, and my lord, a question of laws has been framed, my lord.
In appeal case, or it should be first FMA, first miscellaneous, because the matter
No,
is
second appeal. second appeal, my lord, because I tell your lordship, issues was framed with regard to maintainability. Issue was framed with regard to maintainability, and the suit was initially dismissed, thereafter allowed by the appellate court below. It's a second appeal. It's a second appeal, my lord.
Okay, record and order. Learned advocates for the parties are present. On the prayer of the learned advocates, the matter stands adjourned. Let this matter appear on 7/1/2026 under the heading application. The interim order is continuing.
No, my lord. Interim order, my lord, got expired. Can seize my application for reimposition of the interim order.
Execution process. Oh, no question of execution proceeding.
Execution, my lord. Question of my lord. Proceeding of the suit, my lord.
No, when is the next date before trial court?
My lord, next date is on my lord 2nd of February. 2nd of February is the next date.
No urgency.
Grateful lordship. Grateful lordship.
My lord, I am for the appellant. My lord, it is a second appeal, and my lord, so far my knowledge is concerned, second appeal is to be admitted by the honorable division bench.
Oh, it is not yet admitted.
Not yet
You
admitted.
are for
my
the
lord.
appellate.
I am for the appellant. my
Yes,
lord.
record and order. As this bench does not have any determination to hear this appeal, as the same is not admitted, let the matter be released from this list and placed before the honorable division bench having determination.
Yes, my lord. Grateful. my lord.
29, my lord, I'm for the appellant defendant, my lord.
I am appear for the respondent.
My lord, this is CAN 2 of 2025, my lord. That is for extension of interim order, my lord. My lord, this is second.
My lord.
My lord, let me place my submission, my lord, first.
No, CAN 2 is for extension of what interim order?
My lord, I'll tell you, lordship. My lord, the appeal was admitted, my lord, and my lord, the interim order was granted, my lord. It expired on 24th of November, my lord.
No, what is the interim order?
My lord, stay of operation of, my lord, the judgment and decree.
Okay. Execution
Of the-
proceedings is pending.
No, my
Execution
lord.
proceeding was pending. Execution was carried out.
My lord,
and
I have
they have
not.
suppressed the fact before the
No, my lord.
bench.
My lord,
and execution has
I have not
been
received.
completed.
I have not
And
received
in
any
such
notice as
way,
regards to
interim order was
execution, my lord.
obtained in this fashion, my
No,
lord.
absolutely not, my lord. I have not received any, my lord, notice regards to, my lord, execution.
Kindly see.
My lord, few local goons, my lord, came to my
But
premises and,
it
my lord,
was not
evicted
for
me.
the local goons. The court bailiff went and execution has been completed, my lord. This is not the fashion of this court, my lord. The suppressing such facts.
Absolutely not.
And an interim order was obtained and it was not placed before the court.
Absolutely not, my lord.
Kindly cease. I have a,
But there is no notice of service, my
Filed
lord,
any
to my
opposition
client, my
to
lord.
this effect?
the question doesn't, because the execution has been.
You state in by way of oath.
Yes,
I shall.
Yes,
I
record
shall.
and order.
Let that be on affidavit, my lord.
But kindly do not extend the interim order. I
That
am
cannot be
strongly
done,
opposing
my lord.
because there is no scope of interim order at the present stage.
Let him place his submission, my lord, by way of affidavit, my lord.
Obviously,
My lord, in the meantime, my lord, let that interim order be extended.
340 proceedings should be initiated against him.
Honored advocates for the parties are present.
We have been evicted by court.
Yes, he has been evicted by the court.
This
What remains is the
application
proceeding.
application for stay of the judgment and decree passed by the learned trial court is taken up for consideration. It is submitted by the learned advocate for the appellant, respondent, that the decree has already been executed
through court.
Through court.
But we have not been.
Thus, the
And my lord, I am opposed to that.
It is disputed by the learned advocate for the appellant. Thus, the respondents are granted opportunity to file an affidavit to opposition, bringing the relevant facts.
My lord.
Bringing the relevant facts. Let this matter appear on. Let the affidavit in opposition be filed on or before 12/12/2025. Reply, if any, no, affidavit in opposition be filed on or before 17/12/2025. Reply, if any, by 24/12/2025. Let this matter appear for further consideration on 13/1/2026.
Well, there is a copy of the
let there be
execution
a-
positively kept with record.
There shall be no further proceedings with regard to execution case number.
Execution has been disposed of. Kindly seize the certified copy.
Lord, the judgment and decree, my lord.
Yes, kindly seize the execution proceeding. I have, this is a certified copy, last portion.
Let them produce by affidavit, my lord.
The certified copy. The received full and vacant khas possession to suit to court.
And I have not received any notice regards to that.
He is not in possession in the property.
13/8/2025. Okay.
On 12/8, my last portion, last page.
No,
Last
where
page.
is- Last page. No, where is the order disposing this execution?
Well, kindly seize, my lord.
Okay, just the execution case, if not disposed, be not proceeded with further.
The execution case.
Pending before the trial court, if not disposed, be not proceeded further.
And my lord, let there be a limited stay.
No,
For that
there is
period,
no
a
possible
limited stay, my lord.
No, till the next date.
Everything is a limit, my
execution
lord.
case-
Everything is a limit.
Execution case, if not disposed, be not proceeded further.
Absolutely.
তাহলে মানে ওই স্টেটে তো ওইরকমই থাকবে তো
হ্যাঁ, ওই তো যেটা বলে দিলাম ওইটাই, not to be proceeded further.
ঠিক আছে
My lord, these are the services, my lord. Let this be kept with the record.
তাহলে not today থাক, তারপরটা ইয়ে হয়ে
No, my lord, item number 28, already
28.
order passed, my lord. But my lord, name and case number is in the list is okay, my lord. But the file is different, my lord.
My lord, may I just
28, let the order be recalled, let it be not today just. Or let it go out of the list.
Go out the list.
Yes, item 28 একটা order লিখে নিন তো। 28 order হয়েছে? আচ্ছা, the item 28, the matter is coming, is appearing in the list by mistake, let it go out of the list.
My lord, item number
Mistake is in a
29,
case
my lord.
file.
28.
My lord, 29, my lord. My lord, this is the affidavit of service, my lord, which was going on. মামলার মাঝে
Oh, ফাইলটা আছে 23-এ।
Yes, my lord.
আচ্ছা, I'm just making it not today, it will not appear on the next day. Because different file is there.
তাহলে 28-এর অর্ডারটা কেটে আর ওই 29-এর ইয়ে বলছে
Affidavit of service file be kept with the record.
But my lord, only not today, but it will not appear in the list, my
Yes,
lord.
yes. it will not.
29.
Sure.
Grateful.
আপনাদের নামটা দেবেন
My lord, I beg to appear for the, my lord, appellant applicant. My lord, according to my calculation, my lord, 3 days delay is there. But my lord, perhaps in the office report, they have note down there is no
Service upon the opposite
my
respondent
lord,
is complete.
OP number 2 has filed a caveat prior to that. I served upon him.
No, section 5 has to be served upon all.
I will, my lord. This is the first time it is coming before your lordship. But if the department submit a report that there is no
Anyway, that will be inquired later on. You cause service first.
My
Yes, item 30, record and order. Learned
lord, I
advocate.
served, but my mistake on my part, I mentioned the wrong judge's name. My lord.
Yes.
I have served upon the caveat who filed the caveat, but my lord, the honorable judge's name wrongly mentioned because it's a second appeal. I mentioned that.
Serve again. Learned advocate for the appellant is present. Let this matter appear on 7/1/2026. Learned advocate for the appellant is
I can withdraw the CAN application as well. If office report says there is no delay, then unnecessarily, my lord.
whatever it is, a learned advocate for the appellant is requested to cause service of the petition upon the respondents.
Opposite parties.
Respondents.
My lord, one prayer, my lord, kindly take the cause title, my lord. I just want to, my lord, remove one name because his name mentioned twice, my lord.
Liberty is granted to the learned advocate to cause necessary amendment in the cause title.
Yes, yes. Mithun Ghorai, my lord, I mentioned as a OP number 2, but subsequently 2A I have also mentioned.
Okay. Yes, liberty granted to rectify the cause title.
Grateful, my lord. Hey, the service. Hey.
One.
My lord, I am for the appellant. My case is this.
Lordship, I am appearing for the Union of India.
So paper books are ready?
Yes, paper books ready. My lord, this is for your copy.
Lordship, I am seeking some time to come back with instructions to Lordship. I sought instructions but I have not received the same. Kindly grant the short.
Yes, record an order.
My lord, it is a case of 11. And RCT took the time 11 years to get it disposed of.
Has just been assigned to me,
Disposed of
Lordship, therefore I
22.
will proceed.
That widow lady is suffering too much without his husband, and actually
I understand your Lordship will give a short date.
field workers.
Just wait for 2 weeks. You have waited for so long, 2018.
Yeah.
You just wait 2 or 3 weeks.
Yes.
Learned advocate for the parties are present on the prayer of learned advocate for the respondent Union of India. Time is granted to seek necessary instructions. Let this matter appear on 8/1/2026. এই 8 তারিখে দেখুন তো কোনো ম্যাটার ফিক্স আছে কিনা? 8/1
ঠিক আছে, 8 তারিখ দেখো না কোনবার হচ্ছে। 8 তারিখ বোধহয় ঠিক আছে, ভেরি গুড।
Lordship, 8th I have some difficulty. It can be any other day. Lordship.
7 তারিখে?
7 তারিখে?
না, 8 তারিখে কটায় ফিক্সড আছে? 3টে ফিক্স আছে। Yes, I am keeping it on 8th of January. Instructions.
Lordship, 8th I have some difficulty any other day. 7th, 9th, any day before or after. I'll be Lordship.
পরের উইকে দেখুন তো 13/14-তে 14 তারিখে 14 তারিখে? আচ্ছা 14 তারিখে দুটোই নেই। Okay, 14/1/2026 at 2 p.m.
I'm grateful.
May I please allow to serve the paper books to the authority concerned?
Yes, the paper books. Are you filing it?
I have already filed.
Okay, the paper books file be kept with the record and served upon the opposite party.
Advocate ka appeal pade gache direct advocate ke diye do.
দিয়ে দিয়েছি তো পেপার বুকস। হ্যাঁ,
বন্ডে রয়েছে
দেখুন দিলাম, এক্ষুনি দিলাম।
That I am for the appellant in this matter, Malad.
Obliged.
I am appearing for the respondent. Malad, the issue involved in this matter is, Malad, the claim case was awarded on behalf of the claimants, Malad. Initially, in the claim application, they disclosed a policy number. The claim application was.
I think this is the matter you took time to prepare a supplementary paper book.
Malad,
it was illegible.
No.
There is a delay of 11 and.
Malad, may I place my case, Malad? No. That may I place my case? May I place my case?
Yes.
The claim application was amended.
Application
Yes. Malad, the claim application was amended. They changed the policy number. The photocopy of the policy.
Question is first this application, your appeal has to be admitted by conducting the delay.
Yes. Malad, I'll just give me
what
a
is
minute.
the delay?
Malad, there was a 47 application pending before the execution court. It was dismissed in 2024 and the appeal has been preferred in 2025. Since there was a section 47 application pending before the execution court, Malad, parallel proceeding could not have been done. That is the reason, Malad, there is a delay. The original award is of 2014, Malad, and the execution application is still pending before the learned court below. Malad, the allegation is serious because the subsequent policy was never renewed at the behest of the insurance company. I have taken out an application under Order 41 Rule 27 disclosing those documents. Malad, if the
paper books have been filed.
No, it has not been admitted. Malad.
Oh, section. What is the section 5?
Malad, can 2. Malad, all I am praying, Malad, your lordship is in session of the matter, Malad. My main contention is my Order 41 Rule 27 application. Let my senior learned friend come with an opposition to that application. In the meantime, Malad, let us secure the sum. Because execution proceeding is pending. If it is
22nd September 2025, this matter was heard at length by his our lordship, the Honorable Justice Anandavada, and our lordship desires to dismiss this.
No, Malad, I oppose. No, she has not made any comment. She fixed it for orders, Malad, the order will speak for itself.
Because there is a huge delay. My lord, accident took place in the year 2009.
Malad, they fraudulently obtained the award. Now they are raising their voice, Malad, problem.
Contested the case, fully contested the case. My lord,
file your opposition. If you
no,
exactly, Malad,
my lord,
If you want to oppose it tooth and nail,
Exactly,
you
my
file your opposition.
My lord, your lordship, kindly, my lord, I am verbally opposing the application.
cannot
Your
be.
lordship, kindly go through the, my lord, application for condonation delay. What explanation? My lord, kindly hear, my lord, for a moment. My lord, 2009 accident took place. My client filed an application. My clients are the, my lord, the wife, mother
Under
of
166.
163A.
163A.
Only 4 lakh was awarded. My lord, they have fully contested the claim case. The award was passed on to India 2014. My execution case was filed 2015. After lapse of 5 years, my lord, they filed and new applications under section 47. My lord, that was also not taken, my lord, by the tribunal.
No, you bring these facts on record. Let me.
My lord, everything, my lord, your lordship kindly see, my lord, in application under order 41 rule 27, and your lordship kindly see application for condonation of delay. A delay was about, my lord, 11.5 years. Kindly consider, my lord.
What award was passed in
2014, and the appeal was filed 2025. They are fully aware section 47 is not maintainable. If there is any jurisdiction in error, there is, and even if Mala, they have fully contested the claim case. The Mala, they have never produced any evidence. We filed the insurance policy and we filed the
photocopy was filed. Original was never
Where is the
exhibited.
order passed by the executive?
Your lordship, I
Sir, kindly takes up my.
Kindly see the award. The memorandum I appeal.
That means they have not complied.
Yes, they have not complied. Even if my lord,
No, you see one thing.
My lord.
Even assuming if your section 5 is allowed also, you have to secure that amount.
Well, that is what I'm praying, my lord. I am not requesting your lordship to dispose it of as of date. What I'm praying, your lordship is in season of the matter. Now, my entire contention is my order 41 rule 27 application.
No, but prior to that, you have to secure that amount.
Well, that is what I'm praying. Let me secure it before the learned registrar general. Well, your lordship will hear out this application. If my application succeeds, I have an appeal. If it don't, all they want is the money, my lord.
My lord, the application under section 47 was dismissed with cost 1 lakh.
Where is that order?
My lord, your lordship kindly
Page.
Page 34 of my can 1. The ground on which it was dismissed, that no appeal has been preferred from the original award.
Yes, that was the law.
That is the ground.
Have you challenged that order of section 47?
No, my lord, because the court said it cannot travel beyond the decree. So my remedy was to challenge the original award. That is what has happened in
2009, and after 26 years, my lord, after my lord,
it starts from page 34, my lord, can 1.
Page 34.
34, my lord. I can say D, my lord.
Yes.
Your lordship kindly see, it is in order.
(27) 2024.
My lord.
And you have preferred this application when?
My lord, appeal filed on. My lord, I'll give you lot.
2018.
No. 24.
March 2025.
47, it was dismissed.
March 2025, my lord. My lord, I had to obtain the original award, certified copy, then I filed the appeal, March 2025. My lord, if you lost it,
the award was passed on, my lord, 27, 2024. There is no explanation for delaying the mandal after passing the mandal, the order passed by the mandal in a petition.
If your lordship
insufficient mandal, the explanation.
I have been
Award was
penalized.
passed 2014.
I have been.
They have waited.
I
We file an execution case. In 2019, they have come with an application under order 47. That was not allowed. And thereafter, the order was passed with a cost of 1 lakh. They have not paid. They have not paid any single funding. Kindly visualize. It is a 163 case.
Cost is concerned, I have to pay. I know.
No,
But the policy is
Hospital
concerned.
So
if it
cost
was
was
not-
awarded you by the trial court.
My lord,
cost was awarded by the trial court
the
in a
delay.
pay. No,
For the
for my lord, for misconceived application under section 47 of the CPC, that was not given. Mother, simplicity, mother, they are fully award. The award can be challenged in an appeal. In spite of they have waited 5 years, they find a my lord. Even if my lord, they have got the enough opportunity to contest the case
So have
and to
you,
go to.
you see, if you have not challenged that award, that's cost, that is
my lord,
binding
I don't
upon you.
challenge this.
Yes.
I was penalized. My lord,
Now
I'm
the
ready and
question, you
willing
pay
to-
the cost and
My lord,
then trial shall take it up.
I'll along with the award, I will secure that before the learned registration. I am entirely aware of the consequences. But the kindly visualize the situation. A policy which was not renewed on the date of accident, my lord, they cannot claim a benefit out of that. My lord, that is the sum and substance of the case.
They could
Your
have
lordship will
no,
decide
this
that
is not
time.
a case. They could have asked before the tribunal.
Well,
They have fully
That is
contested.
the case that was
They
not discovered.
cross-examined
That
my
was
client.
discovered at a later
And
stage.
even if no document was filed, no criminal case was filed, the policy which was handed over to him and which was exhibited.
My lord, does that take out my
Malad,
right?
no
My lord,
state.
does that take out
Now,
my right,
Malad,
my lord? My
we
lord, kindly
can
comes to
appeal.
page 18, my lord. I have
And
disclosed everything.
delay of my lord 11 years, they come and say, your lordship kindly condone the delay. If there is a sufficient grounds, my lord,
Kindly allow me
explanation,
to secure the
I do
stamp, my
not
lord, and
object.
decide this
Your
application.
lordship, let it appear as
Hey.
for order.
ये limitation act दिन तो
हाँ, ये
limitation act আছে কি?
Mala Limitation Act has no application. Mala, it is under section 163A, 173 of the Motor Vehicle Act. A Motor Vehicle Act is Mala Motor Vehicle Act, section 176, any appeal preferred by the
No, limitation act.
Mala, since it is a special act, Motor Vehicle Act, section 173 says, Mala High Court.
ওই দিকটা দেখুন তো ওই দিকে ও এই যে পাওয়া গেছে
And this is my application for condonation delay and appeal.
Without an opposition.
Without opposition, I am
He's making the oral submission. That has to be on record by oath.
Yes, your lordship kindly record my submission.
How can that be, my lord? I'm asking the question to myself, my lord. Let him take out an opposition to that effect, my lord.
My lord, I am verbally argue this case, my lord, before our lordship and before
because I
your
don't have
lordship.
any record what you argue.
My lord,
Your lordship,
with all due respect to my senior learned friend, my lord, no observation was made by your lordship.
My lord, claim application, they have contested the case. They did not give any, my lord, any evidence, neither documentary nor oral evidence. The award was accepted. And my lord, my clients filed an execution case in 2015.
My lord,
and after, my lord, 3 years, they have come with an application, my lord, for that the insurance policy is not genuine.
My lord,
They have, my lord, my client also filed an objection after objections. And ultimately in 2000.
See, power of condonation by the appeal court is there.
Well, kindly.
So, appeal, the time for preferring the appeal is 3 months.
Yes, 3 months.
But if the appeal court is satisfied that the appellant had sufficient cause to prefer this appeal, the delay can be controlled.
Yes, my lord. I am also, my lord, kindly consider my lord, the paragraphs which are stated, my lord, in the application for
kindly
condonation
appreciate,
of
my lord.
delay.
The case is they have fraudulently obtained the award.
Kindly
Your
see,
lordship
my
knows
lord,
it is settled principle of the fraud unveils everything, my lord.
Can to application. Can to application, my lord. This is my lord, the explanation.
Can to application, yes.
Yes, application for condonation of delay. Only 2-3 paragraphs. Is totally, my lord, application is without any explanation. This application is not mentionable, is liable to be dismissed with cost. Simplicity.
Yes, record an order.
Yes.
I'm recording your objection.
Yes.
Learned advocates for the appellant and learned advocate for the respondent are present. The respondent number 1, insurance company are present. Hard learned advocates for the parties. This application can 2 ये হলো learned advocate for the appellant and learned advocate for respondent number 1, 2, 3 and 4 are present. The application for condonation of delay being can 2 of 2025 is taken up for consideration. Heard learned advocates for the parties. The appellant insurance company has filed this application for condonation of delay of 3,914 days. Stop. It is the contention of the appellant that the judgment and award was passed by the learned trial court on 14th March 2014. Thereafter, the appellant discovered that the policy on which the award was passed was a fake one and was never issued by the company. Stop. Pursuant to the award being passed, the claimants filed execution proceedings being MSCC execution case number 1 of 2025. 2015. The appellant insurance company, being the judgment debtor, filed an application under section 47 of the Code of Civil Procedure. Stop. The application under section 447 of the Code of Civil Procedure was considered and disposed by the learned trial court stroke executing court
7 July 2024.
on
28 July. 28 July.
2024. By order dated 27/2024, learned trial court was pleased to pass the following order. ঠিক আছে? Hence it is পাতাটা fold করে দিচ্ছি। It appears that by the said order, the learned trial court stroke executing court was also pleased to award a cost of rupees 1 lakh upon the appellant insurance company. Learned advocate for the appellant submits that as because the appellant was pursuing case application under section 47 CPC, the appeal was not preferred, and pursuant to the disposal of the case under section 47 CPC, the appellant has come out with this appeal. It further appears from the order dated 20/7/2024 that the application under section 47 of the CPC was not disposed on merits but on the ground of maintainability, and it was on the ground of maintainability, and it was observed that the appellant, without preferring appeal, cannot move application under section 47 CPC. Stop. Application under section 47 CPC. Learned advocate submits that the delay caused by his client is bona fide and the delay be condoned. Stop. Mr. Bonik, learned advocate representing 1 to 4, submits that this application for condonation of delay should not be entertained.
1, 2, 3, my lord.
Meaning for respondent number 1, 2, 3, and 4.
No, 4 is order.
Okay. 1, 2, 3 submits that this application for delay should not be entertained as the appellant has not shown any grounds for condonation, and the application under section 47 CPC was dismissed by the learned trial court by awarding costs of rupees 1 lakh, which the appellant has not paid till today.
Your Lordship, kindly record my submission. The case was filed in 2009. The case was disposed of in 2014. Insurance company had interappearance and contested the case. They have never produced. Kindly record my submission.
Learned advocate also submits that the insurance company, after contesting the case, claim case before the tribunal, has filed this application without any cause. Stop. Upon perusing the petition and upon hearing the learned advocates, upon perusing the petition for condonation of delay and upon hearing the learned advocates and considering the order passed on 27/2024, it appears that pursuant to the judgment and award passed by the learned trial court on, yes, when was the award passed?
14th March
2014.
14th March 2014, the appellant moved application under section 47 CPC
After 5 years.
after 5 years without preferring an appeal. Now the point for consideration is this: whether the appellant is entitled to exclusion of time. Stop. Section 14 of the Limitation Act 1973 provides that in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the defendant, shall be excluded,
Limitation Act
where
has no
the
application.
proceedings relates to the same matter in issue and is prosecuted in good faith in a court which from defect of jurisdiction or other cause of a like nature is unable to entertain it. Although it is submitted by Mr. Bonik that Limitation Act is not applicable in an appeal under
in a case of
in an appeal under Motor Vehicles Act,
Yes.
but as the court have power to condone the delay, the court can also take the principles of the Limitation Act 1963. Upon considering the grounds furnished, although it appears that the award was passed about 11 years ago, until today, the award was not challenged. Thus, the claimants have already suffered a hardship. However, in the interest of justice, as the ground shown deserves consideration, the delay in filing this application should be condoned with certain condition. The first condition on which the delay condoned is the cost which is awarded to the claimants amounting to rupees 1 lakh shall be paid to the claimants within 2 weeks. Upon payment of the costs, this application for condonation of delay will stand allowed. However, in the event there is default in payment of the said costs, as the order of costs was not challenged, awarding costs was not challenged before the higher forum, the award has already reached its finality, which must be complied by the appellant insurance company. Thus, the cost shall be paid within a period of 3 weeks. And upon payment of the costs, the delay shall be condoned.
Delay while condoned without cost.
No, upon payment.
But that was one given by the trial court.
Yes.
But this court,
just a minute.
30914.
However, there is also a further delay from the date when the trial court order under section 47 is passed. For such purpose, a further costs of rupees 5,000 shall be paid.
5,000 only.
In the event the cost is not paid, this application for condonation will stand dismissed and this order will stand recalled. Fix.
Maladu.
7/1/2026 for payment of the costs.
I'll hand over.
Yes. No, you hand it over to, you can hand it over to the claimants or to his learned advocate.
I'll hand it over in court.
You hand it over to in court also.
To whom the will it be divided in 3 equal?
In the name of the parties.
Then three checks will be.
3 checks. The costs be distributed.
Your lordship is disposing on the application because on 6 your lordship is fixing the matter.
For payment report.
For payment report.
Yes.
And my lord, if my clients be able to to take affidavit opposition, we shall file.
No, you see, I am disposing it without affidavit because you said you are not willing to file affidavit. So on your oral opposition, I have recorded it and I have disposed it.
Your lordship, recording the claim case was filed, the award was passed, but after award, the 5 years was passed.
Whatever it is, you see.
Your lordship has not recorded.
I have recorded everything. Now the question is, I am allowing this application subject to the payment of cost as awarded by the trial court. If they don't pay the cost, this application for condonation of delay will go. This is the observation. 1 lakh that cost and 5,000 for this delay.
And the awarded amount?
No, that they have to come with a separate application.
The stay application is there, my lord. Stay application is there, my lord.
No. Are you proceeding? You see, just a minute. As the matter is sub judice before this court, and the insurance company is directed, is given time to comply this order, the parties may seek adjournment before the trial court with regard to the execution proceedings, which may be considered.
I'm grateful, my lord.
My lord, your lordship kindly record, since it is a case under 163,
which may be considered.
Since it is a case under 163, our High Court division bench passes that in case of a 163 in a fatal accident, 5 lakhs should be granted. And that award, that order was upheld by the Honorable Supreme Court.
See, I am not.
We filed a court. Kindly record, my court.
No, your court is also delayed.
Not court delay, delay. What delay?
No.
Appeal not
you are also filing after a long period.
No.
That has not been served upon.
My lord, cross appeal in connection with this appeal. Appeal not now raised.
I am coming out with a condemnation of delay. He had argued so much, and now he says he don't require a condemnation of delay.
That will not be taken into consideration.
But it has not been served upon me, my lord.
My lord, your lordship kindly.
Submission made, not a single submission made regarding that point.
If the appeal not registered, even if my clients file a court, there would be no delay. That is the law. If the appeal be court has been filed on my lord.
Anyway, come on the next day. Let them pay the cost. Let them come on the next day.
I'm grateful to your lordship, my lord.
No. Cost of payment hole তারপর disposed হবে. না, subject to the condition. ওটা দেখাবেন অর্ডারটা আমাকে, আমি বলে দেবো আর কি.
Petition is still pending.
Yes. On the payment of the costs, it will be made absolute. And if it is not paid, it will be recalled.
I'm grateful to you.
6 তারিখে আছে 6/1/2026 7/1 7/1 ঠিক আছে
Well, next item is only for paper book.
Yes.
Finding time for paper book. Bring time for paper book.
Yes,
Other
which
side,
item?
I need 34, my lord.
Yes, learned advocate for the 34. Learned advocate for the appellant is present. Learned
I'm for the respondent, your lordship.
learned advocate for the parties are present. Learned advocate for the appellant prays for time to file the paper book. Such time is allowed. Let the paper book be filed on or before 16/1/2026. Let this matter appear for hearing on 21/1/2026.
And my lord, 4 copies, my lord. 4 copies
Copy
of.
may be served.
The copies after the requisite number of copies.
My lord,
after
let it be 4, my lord. Otherwise, it will be 8.
Okay. Let it be. Why? It is a difficulty to file late copies.
8 copies, my lord. It is unnecessary. It is also it is unofficially.
4 copies be filed and a copy be served upon the opposite party.
And affidavit of service may be kept.
The affidavit of service file be kept with the record.
Lordship, since we are receiving the copy in the court, your lordship, 2 copies may be served upon us, one for the department, your
I
lordship.
have directed.
Lordship.
4 copies.
Copies be served.
No, what a time.
All the pictures.
One.
Lordship, Mr. Rajiv Bhattacharya is on his legs in another matter. So he has told me to take notes for this.
Yes.
Yeah.
Today your learned friend will be submitting.
Yeah. So I'll take note of that.
Yes.
Yes. Brief recapitulation, my lord. I was placing part of the judgment, impugned judgment and order. Before that, I say, my lord, the plaintiffs are cooperative housing society, registered cooperative housing society, registered under the Act of 1940, Cooperative Societies Act 1940, and at present governed under the West Bengal Cooperative Societies Act 2006. In pursuance to their object, they purchased different parts of land, prepared a scheme, housing scheme, having many facilities, a mini township. And in that society, the predecessor in interest, that means the original defendant appellant's father, was engaged as a caretaker. Subsequently, he was dismissed, but he refused to vacate the quarter or the accommodation provided by the society, and his son claimed possession on the said property. Thereafter, the society filed a suit which was decreed against the defendant, and the defendant preferred an appeal before the first appellate court, which was dismissed on the ground of limitation. And on the ground of limitation, this appeal has been admitted, and there are two issues have been framed relating to limitation. But while submitting, my learned friend has pointed out the point of jurisdiction, and he has also submitted that the point of jurisdiction can be taken up at any stage of the suit or any stage of the proceedings, including in the second appeal. And he also relied upon certain judgment where in the second appeal also, the High Court is at liberty to frame additional substantial questions of law, or can enter into the question of jurisdiction if there is an inherent lack of jurisdiction, because point of limitation also relates to jurisdiction. Now, this is the background of the case, my lord. I will be submitting on that point later on, but at the moment, let me place my case on the point of limitation. Now, if your lordship kindly take up the paper book, page 93. This part I have already referred to. Last paragraph at page 92. 93.
Yes. 93.
93, my lord. Your lordship got it?
Yes.
Last paragraph. Learned advocate of the respondents argued that the judgment was passed in the law court on 19/3/2008. Certified copy of the judgment and decree was applied on 26 November 2008. Court fees were notified on 10/12/2008. Folios and court fees were deposited on the same date. Certified copy was ready for delivery on 20/12/2008. Certified copy was taken on delivery on 2/4/2009. So that's mean, my lord, the certified copy of the impugned judgment on order was ready for delivery on December 20, 2008. But it was taken delivery on April 2nd, 2009. That is almost 3.5 months later, when the copy was ready for delivery. Now,
yes.
Now, my lord, in support to the case,
so March,
the respondents,
the judgment was passed November.
Judgment was delivered in the law court on 19th March 2008. Certified copy of the judgment and decree was applied for on 26/11/2008.
Yes.
That is almost 9 months later on, not 8 months later on. Court fees were notified on 10/12/2008. That is after 15 days. Folios and court fees were deposited on the same date.
Yes. So court
Cert-
fees were deposited on
the same date. And certified copy was made ready for delivery on 20th December 2008. But the delivery was taken on only on 2nd of April 2009. Now the respondents, my lord, before the first appellate court relied on several judgments delivered by the Honorable Supreme Court as well as by different high courts, including the Calcutta High Court, in support to their case that the limitation is not liable to be condoned. Now, if your lordship kindly come to page 99, I am not troubling your lordship going through the judgments and all those judgments which had been cited by the respondents before the first appellate court.
Yes.
You kindly come to 99 page, my lord. This is the decision with reason in the first appeal. Heard both sides, perused the materials on record and the judgments of different honorable apex court and high courts. It cannot be different honorable apex court, one different high courts cited by both the learned advocate. It transpired from the record that the plaintiff respondent instituted suit for declaration, recovery of khas possession, decree of main profit along with other release before the court of the learned civil judge senior division at Alipur against the appellant defendants, and the same has been treated as title suit number 163 of 1993. And after receiving summons, the defendant appellants contested the same by filing a written statement in the court of the learned civil judge senior division 5th court at Alipur, and the plaintiffs adduced evidence on their behalf, and the defendant number 1 adduced evidence as DW1. But his cross-examination could not be completed for his repeated non-appearance in the court, and at last, on 19/3/2008, learned lower court decreed the suit in favor of the plaintiffs. So it was a contested matter before the trial court, and the DW1, that is the original defendant number 1 or the deceased appellant number 1, was examined as DW1, but his cross-examination could not be concluded because of his non-appearance or because of his appearance on subsequent dates. And ultimately that was concluded and the judgment was delivered on 19th of March 2008. Appeal was, now this is relevant portion, my lord. Appeal was filed on 27/7/2009. An application for condonation was delay was filed on 28/8/2009. That means when the appeal was filed, it was not accompanied by an application for condonation of delay. Admittedly, they had
filed on 27/7/2009.
That is the appeal. That is the appeal, my lord. The application for condonation of delay was filed 1 month later. That was on 28 August 2009.
Anyway, you see, upon filing the appeal after the period of limitation, if section 5 application is not filed, it is defective. So the question is that section 5, unless it is filed, that defect remains.
Definitely.
So anyway,
he has filed belatedly.
It has to be filed. Okay. The court has to see after how many days the party has filed the appeal. That is the explanation.
Right.
That is a defect. If he does not file this section 5, that is a defect.
Then the appeal is not admitted.
Yes, unless the defect is cured, the appeal will not be taken up.
Right. I am obliged, my lord. But what I want to point out, why I am citing this, to show the conduct of the respondent. Whether he was diligent in pursuing his case or the appeal. This
Anyway, you
is
see,
this is
these
relevant because of this.
parties have nothing to do. Whatever they are advised, they will do that. You know this very well. Whether section 5 or they will, whatever they will be advised, they will do that. Because nothing, they have to put their signatures in the petition.
Now kindly turn to page 100, my lord. Second para, my lord.
Yes.
Now the main question that arises for my consideration is what are the compelling
101.
That is 100, my lord. Page 100.
101. Yes, which para? Middle one.
Middle one. Second para.
No, second para is exhibit 5 is a
No,
prescription.
no, page 100, 100.
100. Yes.
Now the main question that arises for my consideration is what are the compelling circumstances that delayed the appellants in filing the appeal after 496 days? Kindly take note of the number of days delay. 496. But the case made out by the appellants that the delay was of 439 or 439 days delay or something like that. Now the first plea that has been taken by the appellant is that the appellant number 1 was so seriously ill that he could not attend the court from March 2008 and so he has no knowledge about the status of the suit in the law. But from the evidence of the appellant number 1, I find that the appellant number 1 stated that he was admitted to the Fearless Hospital in the year 2003 and Exhibit 3 and Exhibit 4 reveal the same. Appellant number 1 also stated that he last attended the court on 29/1/2008. But due to his illness, he could not adduce evidence and the next date was fixed on 15th of February 2008. But since then, he could not attend court due to severe illness. Let us see what documents have been placed by the appellants to prove the same. Exhibit 5 is a prescription without any date. Exhibit 6 is a prescription dated 9/12/2005. Exhibit 7 series are 22 pathological reports dated 7/12/2005 to 23/1/2008. Exhibit 8 series of 4 pathological reports dated 10/4/2009. Exhibit 9 series are 3 medical prescriptions dated 13/2/2009, 13/10/2009 and 13/3/2010. Exhibit 10 series are 11 pathological reports dated 14/2009 to 15/3/2010. Exhibit 11 is the prescription dated 21/4/2009. Exhibit 12 is the discharge certificate issued by the Ruby Hospital Limited dated 27/2/2009. Exhibit 13 is the medical report dated 18/9/2009 issued by the Metropolis and Exhibit 14 series of 4 medical prescription dated 21/1/2008 to 6/4/2009. The author of those documents were not produced before the court to prove their authenticity. It is the duty of the appellants to bring the concerned doctor before the court and tender the document. It is not the case the appellant that the said doctors had expired or it would be great hardship for the appellants to produce the doctor before the court of law. So mere the marking documents of exhibits do not dispense with their proof. This is what the learned trial court is relied upon. Now, whether it is right or wrong, your lordship will decide. However, it is the specific plea of the appellant number 1 that he could neither attend the lower court nor make contact with his learned advocate on and from 29/1/2008 as he was seriously ill. But Exhibit 5 and Exhibit 6 are the 2 prescriptions prior to his admission in hospital. So these 2 exhibits bear no relevance. Exhibit 7 series, Exhibit 8 series and Exhibit 10 series are the pathological reports ranging from 2005 to 2010. And none of the said exhibits reflects that the appellant number 1 so physically weak that he failed to make contact with his learned advocate from 29/1/2008 to 24/7/2009. In regard to Exhibit 9 series, there are 3 prescriptions out of which 2 are 13/10/2009 and 13/3/2010, which are beyond the period of limitation and one is of 13/2/2009 and in this prescription, the appellant number 1 was only advised to have some medical tests. Exhibit 11, Exhibit 12 and Exhibit 14 series also do not support the appellant number 1 for not taking any steps in the learned lower court. And Exhibit 13 is the medical report dated 18/9/2009, which is beyond the limitation period. In respect of Exhibit 1, it is the report of a doctor, but unfortunately, the said doctor was not produced before the learned court and the respondent did not get the opportunity to testify the contents of the prescription. Moreover, Exhibit 1 is based on the other exhibits. So, if the other exhibits are not proved to be trustworthy and cogent, then Exhibit 1 has no significance.
No, documents were marked exhibits upon examining this witness.
Upon examining the exhibit are produced, they are tendered and they are marked exhibits.
No, question is, was this matter fixed for evidence, that examination and cross-examination, or simply on the basis of that application?
They have filed an affidavit. It is in the paper book, my lord.
Yes.
It is in the paper.
Suppose there is an examination in chief.
Yes. On the basis of that, the
no. There must be some cross-examination.
It is to be tendered before the court below.
No. Suppose that evidence in chief is to be tendered.
My lord.
Suppose the court does not decide the issue on the basis of affidavits. The court decides the issue on the basis of evidence. Now, this applicant has to adduce evidence by examining him, or if the doctor, whatever it is. Now, at the time of adducing evidence, he has to file examination in chief, and thereafter he has to be examined. Where is that?
Your lordship has tons of experience regarding trial, my lord. I say one thing, my lord.
Yes.
That the normal practice is this, that affidavit of evidence is to be filed.
No, question is, you see, at the trial of the suit, you see, this is an application, restoration application or application under section 5. If the
Suppose
court,
there is a miscase, my lord.
yes, whatever it is, if the court thinks, or in the maintenance
Yes.
event, if the court is of the view that the matter cannot be decided by affidavits,
without evidence,
the court will fix a date for evidence and permit the parties to adduce evidence. Where is that order passed by the court, and where is that evidence? And if there is an evidence, there must be cross-examination.
Yes.
So, where is that? Just because this observation exhibit, how these are marked exhibit?
That is the question which I want to raise for your lordship.
See, whatever was the proceedings, it must be there in the record. If it is on evidence, the evidence has to be produced. What evidence was adduced?
Yes.
And if the evidence is not there, the court decided to decide it on affidavit.
Both sides agreed and it was marked as the exhibit.
That means, you see, then, you see, I have to go through the records, and if there is no evidence on affidavits, or the matter is not decided on evidence, I have to observe that yes, no evidence was taken.
Yes.
It was only decided on affidavit.
On affidavit. Now, kindly come to page 75 for once, my lord. Turning back to the affidavit in chief, which your lordship is referring to.
Page 75.
Page 75 of the paper book, my lord.
That is your affidavit.
No, that is the affidavit of the appellant.
No, you see, that is affidavit in opposition or objection, as you may say. This is affidavit in objection, probably. Oh, affidavit, yes, affidavit to examination.
Yes. Affidavit as to examination chief of Sri Manoj Kumar Chakraborty in the instant case under Order 18, Rule 4 of the Code of Civil Procedure.
Where is that cross-examination?
Cross-examination is not in the paper book, my lord.
No. So how is that? See, when an examination in chief is done, if there is no cross-examination, it is deemed to be admitted.
There was an examination under instruction I am submitting, my lord.
See, any case which is to be decided on evidence.
Kindly come to page 84, my lord. That is the continuation of the affidavit.
84?
84, page 84.
Yes. No. Question is, you see, these documents, you see, first of all, after preparing this examination in chief,
yes,
it is tendered.
Yes.
There will be 2 lines order.
Yes.
This examination is chief is filed. Okay. The evidence of PW1 is in the form of affidavit.
Absolutely.
So examination in chief is filed in the form of affidavit.
Yes.
Okay.
Yes.
It is tendered.
Yes.
They will say that here they have read, understood, and signed the affidavit. Now, one after another, the documents will be tendered. And after producing the documents, it will be marked exhibits. Now, if the question is, if the maker of the documents is not examined, the court may not mark these documents as exhibits. That is the discretion of the court. But the court it is marked as exhibit without any objection also.
I got your lordship's view. What is the practice, my lord, and generally which is to be followed are followed. That when the affidavit in chief is filed in the court below, thereafter the witness is examined and he has to tender it before the court. Then the court marks it as exhibit.
Moment you see
Whether it is written on
whether he was cross-examined or not, there is no such.
no, in the my instruction that he was cross-examined.
Anyway, then you file.
But then it is to be it is there in the but be that as it may, I can't let me continue.
Let us know the facts. Thereafter, the court can proceed on the law. Let us know the picture.
Let me have the law court for a moment. Kindly spare me for a moment. একটু LCR টা দিন.
No, if they have not.
Because this is prepared by the appellant, my lord.
So let him file a supplementary paper book incorporating the others.
If it is there, I will check it here and now, man.
Otherwise, you see, it is accepted.
I understand. I got the view of your lordship. দাঁড়াও না, উল্টো পাল্টা আছে তো সব। ওইভাবে কি অর্ডার দেখে? এফিডেভিট তো থাকবে, এতে থাকবে, বক্সে থাকবে। Title appeal to the for 2015.
That means instead of exhibit, it ought to have been stated annexure.
Yes.
After it is proved, it will be marked as exhibit.
My lord. My lord, order number 18, dated 26/8/2011, read as follows. The appellant's petition under Section 5 of the Limitation Act, raised with Section 151 of the CPC, praying for condonation of delay in filing the appeal, is taken up for hearing. At this stage, learned advocate appearing for the respondent number 1 and 2 submits that the appellants are required to prove the cause of delay by adducing evidence. According to him, the appellants have miserably failed to explain 439 days delay in filing the appeal, whereas actually it is 496 days. In such circumstances, hearing has gone fixed 8/11/2000 for evidence of the appellants.
Yes. So if there is evidence, there is a cross-examination.
So here he must have been examined. To be which Harira. Yes, parties filed Harira, PW1 is further cross-examined. Parties filed Harira, PW1 is cross-examined. Appellant files.
So this it was the witness was
cross-examined and he was
Total, how many witnesses examined? Only one.
Only one.
So let this cross-examination be filed by way of supplementary paper books. Yes, record an order. Learned advocates for the parties are present.
And then the direction will be upon the appellants.
Yes, learned advocates for the parties are present. Your name, please.
My name is Kamal Krishna Pathak. Kamal Pathak.
Mr. Pathak. Mr. Pathak, learned counsel for the respondent, submits but could not conclude his submissions. However, at this stage, some irregularity in the paper book is brought to the notice. It appears that although the witness PW1 was examined in chief and cross-examined, but the said cross-examination does not appear in the paper books. Thus, the learned advocate for the appellant is requested to file a supplementary paper book on or before 6/1/2026 upon service of a copy incorporating the evidence of cross-examination or any other relevant documents if left out. Let this matter appear on 15/1/2026.
Obliged.
So after producing the supplementary affidavit, if you can conclude well and
I will conclude in a day, my lord. I
because
want
that
much
has to
time.
be gone into what was the point
Yes,
taken.
yes, I got the point. Yes, absolutely. Because since it has been marked exhibit.
Yes, had there
once
been
it
no
has been marked-
cross-examination, it would have been another thing.
Yes, since it has been marked exhibit, then your lordship is, as your lordship has already observed, then
Yes.
it is to be considered as proved.
Yes, yes.
But whether the sufficiency of such document is there or not, that is to be decided by your lordship.
Yes, yes. But what are the cross-examinations?
Yes, yes.
That also has to be gone into.
My lord. I take leave of your lord.
Yes, thank you. আচ্ছা,
Grateful, Lord.
এখন আর নেই তো? ওই যে দুটো ওই যেটা জাজমেন্টটা দিয়ে দেবে আপনাকে, ঠিক আছে? হ্যাঁ